with you guys is the, or at least the content from Making a Murderer. Specifically, I wanted to talk about the prosecution of Brendan Dassey. And the reason I wanted to do so is because I was told that the assignment you're working on right now deals with the Dassey case. And can someone tell me what is the assignment that you're doing? What is the main issue you're having to research? Okay, what are the bases for ineffective assistance? Or is that something we want to talk about after this presentation? Is that something that's provided to you, or are you kind of just left to figure out what exactly went wrong in this case? So that's the legal standard. But what about the attorney's conduct in this case was ineffective? Okay, anything else? Yeah.
You just be encouraged to take a plea right away without ever talking about what you wanted to do.
Was there any mention in your assignment about inconsistent theories of prosecution? Okay. I'm going to cover a little bit more than what's in your assignment in this presentation, but one of the things, and then we can come back and talk more specifically about the Strickland case if we have time. I think we will. And to talk about kind of my advice to you on how to approach analyzing an ineffective assistance claim. And then if this later bleeds into your persuasive writing next semester, I think there's some really good topics here that if we continue with the Brendan Dassey theme, may very well end up in a persuasive writing assignment, okay? Where is everybody in terms of watching this documentary series? Who here has not started it yet? Okay, who here has finished it? Okay. So, spoiler alert, both defendants are convicted at the end, right? And that's, well, you have to know that, right? Because otherwise you wouldn't have to make an ineffective assistance claim. Because what is the remedy you're asking for, Mr. Strickland here, what is the remedy you're asking for if you are saying the attorney was ineffective? In other words, if you win, new trial, right? If you win an ineffective assistance claim, it doesn't mean your client is innocent. It just means that they were denied their Sixth Amendment rights to the effective assistance of counsel. So the remedy is not that they walk. The remedy is they get a do-over with an attorney, hopefully this time around, that was actually effective. So that's an important thing. Whenever you approach any case, think about what is the ultimate result that I'm seeking here, right? Under some legal arguments, let's say it was a denial of their Fifth Amendment right, for example. Okay? Let's say they were made to incriminate themselves as part of a coercive confession. Right? The remedy for that may well be an acquittal, even on appeal. But for ineffective assistance, you just get a do-over. That's the best you can do. Okay? So let's talk a minute about the show Making a Murderer. As we all know, it premiered about, I guess, a year ago. I think December 15th or so, 2015. And it was during a big snowstorm. So a lot of people were texting each other, hey, have you seen the show? I had never even heard of it until, in fact, your teaching fellow, Sarah Scrivener, texted me and said, have you seen this? I think you'd really like it because I love to watch documentaries. And, of course, I did watch it, and now it's my number one on my top 50 documentaries of all time list. Right? It's that good. Now, there's some other ones that are really good, too. So who are the main players that we see? Some of this is going to be review. I think the four main people, of course, the elephant in the room, you don't really see much of her, is Teresa Halbach, right? That's what started all of this. And then Stephen Avery is kind of the main character. But I'll tell you, for me, the one that had the biggest emotional impact is Brendan Dassey. And I think that's true for most people. If you take a survey of people, even kind of tough justice, criminal justice types, they may say, no, that's Stephen Avery. I read what they were saying on the media, that some stuff was left out of this show. I think he was guilty. But I think almost everyone would agree that Brendan Dassey got a raw deal, right? Especially when you start to watch that confession video, which, by the way, is available in its entirety on YouTube. And the transcripts of both the Avery and the Dassey trials are available online. So we have access to complete information in this case, at least as far as the criminal process was concerned. And then we have kind of our villain in the case is Ken Kratz, right? Who's actually a pretty good attorney, although pushes some of the ethical boundaries. So when Dean Strang came last week, did you guys get to talk to him much about this case, or did he talk more generally? I got to spend about an hour with him before he started doing some of the school-related activities. And I just thought of this when I was driving over here thinking about this presentation. We never even mentioned Stephen Avery, but we talked about Brendan Dassey a lot. I don't know if he's ever even met Brendan Dassey, but that's just the topic I keep getting drawn to. And that's why I think this is a really good assignment. So you've all seen you mentioned 40 minutes of video, okay? What I think you're referring to is the 40 minutes that was not shown to the jury. And that's the same 40 minutes where Brendan is having a conversation with who? His mom, Barb Janda. Is that her name? I think so. And that's where he makes kind of that strange comment, "They got in my head." But the way that they have a conversation with each other, there is a little bit of an awkwardness. There's a degree of ambiguity. And I think what's really important for you in this assignment when evaluating an ineffective assistance claim is you have to kind of imagine all of the reasons that the attorney may not have wanted to show that to the jury. In fact, I don't know if you know this, but often the way an ineffective assistance claim works is it's not done on what's called direct appeal, okay? The problem with doing ineffective assistance on direct appeal, which means we lost, we're appealing it, is you don't get to add any new information to the record, okay? On appeal, you're entirely confined to something called the record, which consists of two things. Everything that was filed with the clerk of the court in the case, all your filings, and then two, the transcripts of all the hearings before the judge or jury. And often that doesn't provide enough information to be able to evaluate an ineffective assistance of counsel claim. So what they do, often a defendant will do, is file for what's called habeas relief, okay? Something called habeas corpus. And that gives you an opportunity to add new evidence into the record. You can actually put the defense attorney on the stand, this is how it works, and say, what was your strategy, if any, in not showing that to the jury? And they will often have some kind of silly reason that doesn't make any sense. And then you argue to the judge that that lacks any trial strategy. Therefore, the defendant was denied their Sixth Amendment right to a fair trial and should get a new trial. Okay. Here, though, this might will be one of the rare circumstances, and they do exist, where there is enough information in the record to be able to make a claim for ineffective assistance of counsel. In other words, we don't need any new information. What we can do is look at exactly what happened, look exactly the deal that was made here, and then perhaps speculate to an extent on what any possible trial strategy could have been, but then quite easily rebut that. Okay? And when I say what deal was made, do you guys know what I'm referring to? Like, he didn't just not show it. Have you guys looked at the transcript from the actual trial about not showing it? Okay. Okay, way in the back. That's right. And I've actually got the transcript here itself. So we'll look at that excerpt, and I'll tell you what day from the trial it came from, so you can actually go look at that in court. But there's a moment where the judge kind of asks, hey, why are we stopping the video here? And the attorneys say, well, essentially, we've agreed not to show the rest of it. And you've got to be very, very precise on what happened when you're talking about any type of an error, but especially ineffective assistance, right? It's one thing to just fail to object because you're not paying attention in court and some bad evidence is coming in against your client. It's another thing to agree with the prosecutor that the most helpful piece of evidence left for you is not relevant in the case. And you can find instances of both things occurring. So I've got a news clip here that kind of gives a background of the Dassey case. I'm actually not going to show this, because everyone has seen it. So that's really helpful. I gave a similar presentation to the Lubbock Area Bar Association. So I showed this because like more than half of the people hadn't even seen the show. Okay. So I'm going to see if I can skip past. Sorry about this. Where do I need to be pushing here? I'm like the old professor all of a sudden. Okay, thank you. Okay, so I don't know if Professor Sherwin told you at all about what I do. I should have said that at the beginning. I'm an appellate attorney. I work for the Federal Public Defender's Office, okay? Before I did federal criminal appeals, I did civil appeals in Texas State Court, and I also did some state criminal defense, all right? So I kind of look at everything from an appellate perspective. And in this case, in your assignment, you are being asked to look at this also from an appellate perspective, because you don't get to the question of ineffective assistance until someone has already lost at trial. Okay? So we're on appeal. So the first question you have to ask, and this is going to go throughout the whole class, and you need to know about this when you do your capstone assignment next semester, which is your appellate brief, is the first question is, what went wrong? In other words, why are we appealing the case? Obviously, we lost on some level. So we need to identify why we lost, and then figure out what could have been done differently to prevent that, right? And that's what you're going to be asking for ultimately in your appellate brief. So when I go back and analyze this, I see that 3 things went wrong for Brendan Dassey. Number 1, he confessed to a crime. That's probably the worst thing that happened to him here. And we all know in the real case, a judge did order that he should receive a new trial because his confession was coerced, right? So that maybe is his strongest argument. Of course, that's been appealed by the prosecutors, so we don't have that new trial yet. So he confessed to a crime. That is a very damning piece of evidence for you if you're a criminal defendant, because juries don't think a person would confess to a crime that they didn't commit, even though we know, as a matter of fact, that people have done it many, many times, and it happens all the time, and everyone in this room is susceptible to that. Okay? Number 2, the way his confession was presented to the jury, major problem, and it sounds like, which is the bulk of your assignment right now, right? There was a problem with the presentation to the jury. What was the problem? We only showed part of the video. We only showed the bad part and left the good part out for some reason, right? And then the third thing, which I find particularly interesting, is what's called inconsistent prosecutorial theories. Meaning, Stephen Avery was prosecuted. He went to trial approximately 45 days before Brendan Dassey's trial. Okay? The prosecutors argued in the Stephen Avery case a theory of what happened that ruled out Brendan Dassey. 45 days later, they argue a different theory of the case that makes him like the main guy, or one of them. And his attorney sat there and didn't object and say, well, 45 days ago you said Brendan Dassey wasn't even there. And there's a very strong basis for that objection, and it's through a theory called judicial estoppel. So those are the 3 things I think went wrong. I think they could have objected to the way the theory of the case and made it conform to the first trial, which would have left Brendan Dassey out. I think they could have shown the exculpatory portion of the confession, which would have at least mitigated some of the damage that the actual confession did. Right? Does everybody know what I mean by that? Okay. And then, number 1, he shouldn't have confessed in the first place. He's in there by himself as a minor. Okay. So, Brendan Dassey's confession. One of the big questions, and this is what led to the reversal, and by the way, when I taught legal practice, my first assignment for you guys next semester, which is the trial brief assignment, was a motion to suppress the confession. So if you guys happen to have an assignment like that, these are the types of cases you're going to be relying on. Okay? And confession law is really 3 main cases that you need to know about, and they take place over a large span of time. Okay? And like any area of the law, you see this trend of how cases develop over time from something that's more principled to something eventually that's more systematic and regimented. And that's exactly what we see here. And by the way, I promise you, if you just did like a Google search on confession or looked at the Wikipedia page, you would have these 3 cases. So you probably don't need to write down every single number, okay? So, but you can continue to do so. So Brand versus United States, it starts very principled, right? A confession has to be free and voluntary. If you make threats or promises, then that can render it not free and not voluntary and thus inadmissible. That's a really, really good case for a defendant. And as we'll see, the law gets worse and worse for a defendant as time goes on. Next, you have in 1959 this Spano case, and you might cover these cases, by the way, next year in criminal procedure. But that's where we implement a balancing test, right? On the one hand, we say it's really important that we have confessions that are free and voluntary, just like we said in Brom. But now we weigh that against a different interest. And this is the law enforcement interest, which is simply the recognition that confessions are very vital when we're trying to prosecute crimes, right? Police officers, part of their job is to get people who have committed a crime to admit to their crime. And that helps a prosecutor do justice, whatever that means, right? As they define it, I'd say. So now we have kind of this balancing test. And then things are still okay here, and then they get really, really bad for the criminal defendant in 1986. And by the way, a lot of things went really, really bad for criminal defendants like 1984, 1985, 1986. If you look at legal history, something about the Supreme Court there changed, right? It's easily traceable. A lot of things went wrong. This is one of them. So Colorado versus Conley implemented a new test. And they said you don't just worry about whether the confession was voluntary. There's a preliminary question you have to answer. And that question is, was it coerced? And this is a 2-step test, and these are not interchangeable. Okay? So how do we think about this? Coercion looks at what the police officer is doing, what the interrogator is doing. They have to be doing affirmative actions that are coercive. And then the second half of the test is looking at voluntariness, which is the characteristics and circumstances of the individual, right? So you can have a person that's highly susceptible, like Brendan Dassey, but now that we have Colorado versus Conley, we have to also prove that the police officer was breaking the rules, not just taking advantage. Do you see what I mean? And it's become very, very difficult to argue that confessions are coerced as a result of Colorado versus Conley, right? And that's one of the big problems that Dassey had for a very long time, just given a new trial, but he's been in jail for over 10 years, okay? So what does coercion look at? It looks at threats and promises. Now there's a question mark here, interrogation techniques. Have you guys heard anyone talk much about police interrogation techniques? Touched on it.
Yes, the read technique.
The read techniques.
There's been a lot of in-class discussion specifically what they did.
Okay. And we're not going to be able to go through that today, but there's a lot of information on the read technique. That's the primary technique used by law enforcement in interrogations. And it's very, very effective at getting a guilty person to admit to a crime. Okay. What's the problem? Yeah, it's also effective at getting an innocent person to admit to a crime. And again, this seems like I would never admit to something I didn't do, but a lot of people have. And we know that now that we have DNA evidence, right? We've had a lot of exonerations, many of which were cases where a person actually confessed. Okay. Now, the reason there's a question mark there is a lot of scholars, a lot of legal scholars have studied the read technique and concluded that it's inherently coercive, right? Because of the very reasons I'm telling you now. No court in the United States has agreed with that. That's why there's a question mark. Other countries have outlawed the use of read technique as inherently coercive. That is not the position of the courts in the United States. It's been essentially adopted. Okay. So does that mean I won't argue it in a confession case, that in addition to these other factors, we have this interrogation technique that's problematic? Of course, I would always argue that. But it's not going to be a winning argument, at least not a standalone winning argument. Okay? Now, voluntariness, we look at the circumstances of the defendant. What was the length, location, and continuity of the interrogation? What about the suspect himself? Maturity, education, physical condition, mental health, right? And were they advised of their rights, right? That can kind of help cure some of these things. And these factors are talked about by the Supreme Court, and so sometimes you'll find a case where it just kind of lists all these factors, and that's really, really helpful, and that's where I got it from. Okay? So, if I'm a doctor, and the reason it says prognosis here, the way appellate attorneys think about things is trial attorneys are like ER surgeons, right? You're making split-second decisions trying to save the life of your client. But appellate attorneys are kind of like medical examiners, right? We're really good at determining the cause of death, but there's usually very little we can do for your client. Okay, trial attorneys think that that's very funny, by the way. Because it's true, right? They lose a case and their client's really counting on that appeal. And sometimes they tell their client, don't worry, we'll win this on appeal, but then they give it to a different attorney. And there's very little we can do sometimes. And I have a question to ask you guys, and it's something that you'll have to think a lot about when you get to your appellate brief, is why would it be harder for an appellate attorney to win a case than a trial attorney when we're talking about the same case?
Can't argue the facts.
Okay, can't argue the facts. Okay, that's you're almost there. Okay, you're right with where I'm talking about.
You're unable to have the law apply to those facts.
Okay, down here.
You're unable to bring in the evidence.
Okay, these are all true. Okay, let me tell you the answer I was looking for, and it's actually all three of those things kind of tied together. Is it something called the standard of review? Okay, so all appellate issues have something called a standard of review, and it differs depending on what the issue is. But if it's a factual issue, we look at it very deferentially. If it's a purely legal issue, are you in what's called a de novo standard review, which means you get a clean look at the case. But otherwise, the appellate court is almost always going to be saying, okay, maybe we would have done it differently, but we're going to defer to what the trial court ruled. And we live and die on standard of review, but it's very difficult to change the facts, just like you said. That's reviewed for what's called clear error, and it's very, very difficult to overcome that. So we're your best shot always to win a case is at the trial level, right? The district court level, the county court at law level. And then on appeal, you can have an impact, but it's usually your second swing or your second bite of the apple is not going to be as sweet as the first one, okay? So from an appellate perspective, first of all, did he win his motion to suppress? No. Can he, under the law? Probably not. Of course, I may be wrong on that. And is his confession reliable? I would answer the question also probably not. And the point here is that we have a legal standard that leads to a certain result, and that result may also be something that we can acknowledge as completely wrong. Right? And that's the problem we face with legal standards sometimes. They lead to results we know are wrong. But that's still the result the court is going to reach. So anyone can say, well, just watch this tape. Obviously, he's being fed every piece of information. This kid doesn't know what he's talking about. He would have, confessed to killing JFK. But we have this case, Colorado versus Conley, for example, that says, of course, his confession is valid. Right? Because the police didn't pin him up against a wall and, put one bullet in the gun and spin it. And what I tell people is in Texas, for coercion to be found, you have to put one bullet in the gun, you have to spin it, you have to hold it to their head, and then you click it once and it's still not coercive. You have to click it a second time before it really counts, which gives you a 1 in 3 chance of getting killed, not just a 1 in 6. That's the way the cases read, essentially. It's very, very difficult in the state of Texas. Now, this is in Wisconsin. Apparently, it's very difficult there. If you read the appellate opinion, when he tried to appeal the suppression issue, the appellate court said, I don't know what you're talking about. Of course this confession is valid. It would be like a total no-brainer if all you did was read the opinion. Okay? So here's where we're going to get to what you're doing here, right? The presentation of the confession to the jury. Now, this is a very short clip, so I do want to play it because this is kind of the heart of that portion that was not shown. So I hope we have audio here. By the way, this is just an aside. The justification at the end, we've been doing this a long time. We know when someone's lying. That has been actually tested in experiments many, many times. And people who are trained to elicit confessions know when someone is actually lying, I think like 55% of the time. 45% of the time they're wrong. Because with the read technique, it looks at certain gestures, certain ways of phrasing, different things that are supposed to be indicators of deception. And many of these things we now know not to be indicators of deception, right? Perhaps they're indicators of nervousness. And I'll tell you, as someone who I don't know that I've committed any major crimes, I am nervous when I talk to a police officer. I'm especially nervous when I'm taking out of class and put into a room with two investigators. And then in many cases, like people I've represented, they try to get them to come in and hook them up to a polygraph. And I'm going to be really, really nervous if I'm hooked up to a polygraph. Right? So these gestures that are of nervousness may not necessarily reflect lying. So, but you guys can read more about that too. Okay? So, as a person, I've got two young sons. They're really young, like 3 years old and a year and a half, but hopefully they get older and older. And this type of thing that really scares me to death. I mean, for those of you that do have kids, this is devastating stuff to watch because this mother is desperate and she's confused and her son is confused and they don't know what's happening. So here's what happened in the trial. You guys want to know this. April 20th, 2007. Write that date down. This is the agreement. Okay, this is taken down by the court reporter. Now, Fallon is the special prosecutor that's brought in for the Dassey case. Just so you know, Ken Kratz is at counsel table here. So he's present for this. He's just not speaking right now. Fallon, who's the prosecutor, says, I believe we've agreed that the remainder of the discussion does not contain pertinent questioning of the defendant, and I think we agreed to stop the tape at this particular moment. That's what the prosecutor is telling the court, right? Runs up and stops it and says that. And the court says, is that true? And Edelstein, our terrible defense attorney that we're trying to throw under the bus, it says, yes, it is. It is true. And the court says, okay, moving along. That's our problem here. Okay, and that's a big problem. So go find that transcript online. I think there's several web pages that might link to it, but it's on April 20th, 2007. Okay? So what's the prognosis? Did he prevail in his claim of ineffective assistance? By the way, in the real case, he claimed ineffective assistance of pretrial counsel, right? That's that guy that sent his investigator in to get that other confession. And then he got a new attorney, right? And the second claim was ineffective assistance of trial counsel, which is this Edelstein guy. And that's the one that you're writing on, trial counsel. But in the real case, they argued ineffective assistance on two separate grounds. Okay? Can he win? I say probably not. Okay, is that because I think he had the effective assistance of counsel? No, of course he didn't. But do I think the hill is that hard to climb? The answer is yes. And if you're reading cases, you will see that you can call no, you can sit there and not cross-examine a single prosecution witness. You can not call any witnesses yourself. You can not raise any objections to any evidence. And the court on appeal will say, that's fine, most of the time. Okay, it's just really difficult. So was it effective? Probably not. So I think this is another good example. I think like the teaching point is you have a legal standard that doesn't necessarily conform to reality. And you see this very frequently. The game is in a sense designed to preserve the judgment of the trial court, right? Because that's what we call judicial economy. We don't like trying a case twice. It seems like a waste of time and a waste of resources. And I'm not saying that the appellate court, that's exactly what they're thinking, but they get ineffective assistance claims filed all the time. And there's no way to prevent that. Any person that's convicted sitting in jail can write up an ineffective assistance claim. And what else do? You're just sitting around. So courts look at these very suspiciously to begin with. Plus, the legal standard is really hard to overcome. Okay? And the third thing I mentioned, and I'm not going to spend really any time on this because I know it's not central to your assignment. I didn't know whether it was inconsistent prosecutorial theories. I just want to tell you, what am I talking about? We have March 15th and then April 25th. Look at what's argued here. These are actual quotes from the prosecutors. The first is in response to Strang and Buting saying, where's any evidence that this murder even occurred in Avery's trailer, right? Because that's exactly what Ken Kratz said in that press conference, told this whole story, kept talking about how sweaty Stephen Avery was. I don't know if you remember that, which was bizarre. But then he talked about this awful bloodbath that occurs in this trailer. And the defense at trial in closing says, where's any DNA evidence? I mean, CSI is like kind of a real thing, and they don't have any DNA evidence of a single drop of blood in that trailer. And Avery stands up and said, of course there wasn't any blood in the trailer, because she wasn't killed there. And what he later says is, no, she wasn't killed till she got to the garage, right? Now, what's the theory of the case in the Dassey trial? It's that Dassey hears some commotion in the trailer, goes and knocks, come on in, And basically, Dassey takes over from there and turns into some wild maniac. Right? The trailer is a bloodbath by the time you get to the Dassey trial on April 25th. Well, that's the closing argument in the Dassey trial. And by the way, this is really true. Ken Kratz on the left is sitting right next to Tom Fallon on the right when he says this. Okay. So, and you can read what it says. It's just, it's an awful scene. But still, there's no DNA evidence to support that, so how was he convicted? Like, what's the only thing that can overcome the fact that there's no evidence to support conviction? It's a confession. A jury will not look past a confession. It just is very, very rare. One of the only instances and best instances I know, I told you my favorite documentary is Making a Murder. My second favorite is called Murder on a Sunday Morning. I don't know if anyone's seen that. Actually won Academy Award for Best Documentary in 2001, and it's about a murder trial where a person confessed and the defense attorney is good enough to make the jury overlook the confession. And it's really, really impressive and really hard to do. Okay? So, by the way, you're not allowed to do this if you're a prosecutor. There's a basis for objection called Judicial Estoppel, which is very, very strong. It started out, it's a Supreme Court thing that they invented in civil cases in like the early 1900s. And now it is applied in criminal cases. And it's simply an objection. You say that the theory of the case is inconsistent in a way that's material to the case. Right? You can't say it's inconsistent in a tangential way, because it's always going to be inconsistent in a tangential way because stories do change over time to an extent. But if it's fundamental to the case, you can't argue this 40 days later or whatever if you argued this that amount of time earlier. So a second ground of ineffective assistance, which apparently is not in your assignment, is he failed to object to the inconsistent argument theory of the case, which is my third reason why things went wrong. Okay? So I'm not going to go through the rest of my slides because you're thinking, well, this is not my assignment. I think this could be your assignment later on. I think it'd be a good one. But I wanted to talk to you a little bit more specific about your assignment, hopefully so you feel like you kind of got something out of this, right? So we talked about this Strickland case earlier. Okay, I thought the screen was down. I was trying to get it to go back up. So, have you all read Strickland versus Washington? Okay, what year did that come out? 84. So it's like kind of like at the tail end of the good Supreme Court, and it starts to get kind of bad after that. But Strickland is a really good one. Okay, and Strickland lays out our way to evaluate ineffective assistance claims. And if there's one thing I want you to remember from all this, and it's one of the most helpful things you can know in legal writing, is let the legal standard organize your discussion for you. Okay? What do I mean by that? If I'm worried about an ineffective assistance claim, I'm not going to just start talking generally about all the reasons I think the attorney is bad. I'm going to structure everything I'm saying around the relevant, applicable legal standard. Okay? So, for example, if I'm making an elements-based argument, my outline of my discussion is going to be element 1, element 2, element 3. I'm going to have a point heading for each one. Right? So, we know that there is a very clearly defined way to evaluate an ineffective assistance claim. Right? How do we do that? What does Strickland tell us that we have to, what two questions do we have to answer to be able to know whether a person had the ineffective assistance of counsel?
That a mistake was made and that impacted the results of the trial.
All right. Does everybody agree with that? Okay, we talk about it a little bit more technically than that. We use two words. So you said a mistake was made, right? We call that the deficiency prong. And the impact we call prejudice. If the answer to both of these is yes, then they had the ineffective assistance of counsel, right? In other words, they were denied their Sixth Amendment right to the effective assistance of counsel, which in effect is the denial of a fair trial. That's the impact. It's a constitutional impact. So what we say is a person was denied their right to the effective assistance of counsel if, number one, their trial counsel was deficient, and number two, that deficiency prejudiced the outcome. So that's how I'm going to organize my discussion. Number one, were they deficient? And number two, did the deficiency prejudice the outcome? If once we do that, it's going to write it for us. Okay? But the question that's even more important here, once we kind of have that two-part framework, is what do we mean by these things? Right? You said mistake, but surely we're not going to allow just any mistake to count as a mistake when we're thinking about giving someone a new trial, right? Then everybody would get a new trial because every trial attorney that tries a case for a week or 10 days is making mistakes every single day. Right? You have someone, I don't know, for you people who are interested in mock trial, for example, let's say the prosecutor has called their witness and they're asking leading questions. And I'm thinking about something else. And I don't object to the question as leading when they're clearly leading. That is a mistake. But I don't know that that means the attorney is deficient, at least not in the sense of Strickland versus Washington. So, does everybody see why it's important to know the way the court is defining these terms? Right? So if you read Strickland versus Washington, we actually have a very precise or a very well laid out kind of boilerplate definition for deficiency. Right? Does anybody know this?
The main error so serious that counsel is not functioning as the counsel guaranteed by the defendant in the Sixth Amendment.
Okay, so that's kind of the way it talks about it early on, right? If you go like 2 pages later in the case, it uses a little bit different language that's not quite as strong. And it's the second way that it talks about it is that every case after it has picked up. And I'll write it for you. But that's absolutely right. That's pretty early in the opinion. And that's some very strong language, right? Fell below a what? Fell below an objective standard, right? Of being a good lawyer or whatever. And what is prejudice? And you have it there, and it gets a little bit different later on, just the same. What do we mean by prejudice?
That it would change the outcome.
Yeah. How do we know?
Trial and trial.
But you don't get a new trial unless we know it would have changed the outcome. So the question is, how do we know it would have changed the outcome? Or can we know? Can we know? We can't know for sure. So that's why here's the standard. There's a reasonable probability that, and this is not showing up on the microphone, I'm just going to say it. There's a reasonable probability that the outcome would have been different.
Do they look at all the evidence at that point in time? Or do they just look at the new evidence or the inadmitted evidence that they're claiming was prejudicial?
That's a good question, and this is an important point, and this is something that's easily missed. So the question is, do you look at all the evidence that came in, or do you just look at the evidence that was being complained of, right? And the answer is, technically you don't look at either, okay? The question is not, did the evidence hurt you? The question is this: did the deficiency that you're complaining of prejudice the outcome? Right? Now, let me give you an example to maybe make a little more sense out of that. Let's say there's a really, really bad piece of evidence that comes in. It's just horrible piece of evidence, and I don't object to it. Right? It comes in, and it's absolutely the reason that I was convicted. So I'm complaining that my attorney was ineffective. I say they were deficient because they didn't object to this one piece of evidence. This is the only piece of evidence in the case. And then I say it was prejudicial because there was no other evidence to convict me. But that's actually wrong. Because what if there was no valid objection at all? What if the evidence is absolutely admissible over any objection? Well, then my argument about the deficiency, failure to object, it wouldn't have affected the outcome at all, because he could have opened up the federal rules of evidence and read every single objection in that book, and it's still coming in. So it's not whether the evidence prejudiced me, it's whether the alleged deficiency. And sometimes a failure to object is not prejudicial at all because there is no objection. Do you see what I'm saying?
A little bit.
Yeah. Well, let's say, but this case is different, right? Because we think maybe there was a valid objection, or there was no strategic reason to make that agreement not to show it, right, in this case. And so we would be complaining the deficiency is the failure to present mitigating evidence to the jury. When we're dealing with the judicial estoppel thing, the inconsistent theories, there the deficiency would be failure to object. But under prejudice, that's where you have to kind of say, and the objection would have worked. Just like in prejudice for your assignment, you have to say, and if they had shown that part to the jury, there's a reasonable outcome. There's a reasonable probability that the outcome would have been different. So you're focused not technically on the evidence itself, although sometimes it kind of conflates. What you're focused on is, did the deficiency that you're complaining of change the outcome? Okay? So if we were to write, for example, a question presented in this case, which, by the way, you're going to have to write, using kind of these standards, these definitions here, how would you word, what is the fundamental question to be answered for your assignment?
Can Brendan Dassey achieve a new trial if he can prove that his counsel fell below an objective standard of deficiency that can reasonably be proven to change the outcome?
Well, I'll tell you, the answer to your question is yes. He's absolutely entitled to a new trial if he can prove both of these, right? So there's actually a more fundamental question is, can he prove that, right? If he can prove it, of course, he's entitled to a new trial. So what is the, first of all, let's identify the problem we're complaining of. And I said it a minute ago. Who screwed up here?
His counsel.
Okay. What did his counsel do to screw up?
Not showing you 40 minutes left in the interrogation.
Okay. So if I'm writing a question presented, everybody's got their pen out now. And you don't have to word it like this, but let's just think through this. And we're organizing all of our thoughts around this standard, right? What's the problem? Did trial counsel's agreement to not show mitigating evidence, or you could say his failure to show mitigating evidence by agreement, you know what I mean? Did the failure to show mitigating evidence And then we come down to what are the two things we have to show. And we're being objective here, by the way. We're not being persuasive, so we're just laying it all out exactly the way it is. Did that failure, what? Yeah. And?
Was there a reasonable probability that the outcome would be different?
Yeah. And but for that failure, is there a reasonable probability the outcome would have been different? Do you see what I mean? It's writing itself once I identified the legal standards, right? Was the trial attorney's failure to show mitigating evidence, did that fall below an objective standard of reasonableness or whatever? And, but for that failure, is there a reasonable probability that the outcome would have been different? That's the legal question that we have to answer to evaluate an ineffective assistance claim. And baked into that question is the very legal standard itself. And then when I do my discussion, part one is an analysis of prong one. Part two is an analysis of prong two. And my conclusion is simply, you wouldn't write it like this, but is the answer to both of those yes? Then yes, he's entitled to a new trial. Is the answer to one of those no? Then he's not entitled to a new trial. Right? It will tell us the outcome. And you have to find cases that help you figure out what it means to fall below an objective standard. And you will find examples where it did. You will find examples where it didn't. And that will help you draw the line of where an objective standard lies. Right? It's a line drawing exercise. But you need... So if this is the world of all possible cases, right? Somewhere in here is your reasonable trial counsel. A person who is objectively reasonable at all times. And the cases and the examples that you're going to find are going to help you know where the line is, where it's, right? You have to figure out where that line is, and that's where your cases come in. So once we can show maybe he crossed the line, then you have to think about prejudice a little bit differently. And then you do have to look at other evidence in the case, right? Because let's say there's no question that there was a deficiency, and had the proper objection been lodged, the evidence would have been the way we wanted it to be, right? We would have that mitigating evidence, for example. But we still have the confession, right? Even if we win what we're arguing, the confession still comes in, unless we can suppress it in a motion to suppress. And maybe there's still other evidence. So it's not enough just to identify that deficiency. In fact, you'll read a lot of cases where they'll say, well, of course trial counsel was deficient. That was a terrible decision here. But there was so much other evidence, the outcome would have been the same. You take that puzzle piece out, you can still tell what the image is. Still the dead body being cut up or whatever they're saying happened here.
Do you look at the evidence most favorably in this case to Brendan Dassey as you would on summary judgment appeal?
Okay, so now we're talking about standard of review, right? And that's an incredibly significant question. And I'll tell you that the standard of review in these cases is kind of weird. Ordinarily, the way it works is a person will file a motion for a new trial after the conviction arguing ineffective assistance, and the trial court will rule on that. I don't know that that's what happened here. If that's what happens, and you'll see this in a lot of your cases, deficiency prong is reviewed for abuse of discretion. So it's different than summary judgment. So you're not asking the question of, is there no evidence, right, that goes the other way? And that's kind of the way it is with summary judgment, where you're saying we take all the evidence in favor of non-moving party and we see if it's enough. Here we're saying, did the trial court abuse its discretion? Meaning, is there no reasonable basis to support the trial court's decision? Okay. But then the appellate courts review prejudice de novo, which means we look at it afresh as a legal issue. Okay? I don't think you should get bogged down into standard of review for this assignment. And your professor may tell you otherwise and then just disregard what I just said. Right? But I think that would be a mistake. If there's no motion for a new trial, the standard review, they simply kind of look at it all de novo. Okay? So, that's the way I would approach this assignment, right? And you're going to find cases that help you figure out where the line of objective reasonableness is. And then you'll find cases that you want to find something that's kind of similar that help you evaluate prejudice. And, what types of things can really affect the outcome of a case. And I don't know the answer to this. If your only complaint is not showing that part of the confession, I think the appellate court says, but you still have the confession. And when the jury hears that, it's reasonable that they would reach the same conclusion even with that mitigating information. But I don't know. When I watched it, I reached the opposite conclusion. Right? I can't watch that discussion with his mom and not feel like he was put through the ringer. So that's something you have to really think about. And you want to use other cases to provide examples of that. All right? Any other questions? Do you guys have any questions about criminal defense or how these cases work or anything like that, about the system, the justice system? Well, I'll just say I hope you guys enjoy the documentary series, and I hope you learn a lot. And for me, it's been one of the best kind of talking points for people. I mean, I have a very particular point of view about the criminal justice system. I actually used to work for a prosecutor's office in Austin a long time ago. And I have a lot of respect for prosecutors. I think we have to have prosecutors, just like we have to have law enforcement, right, if we want to live in a civilized society. But I think there are a lot of ways that the criminal justice system fails people. And I think that making a murderer gives a lot of insight into what a broken process sometimes looks like. So I hope you guys will take that and continue to think about these types of issues. Anything else? Yep.
Did you have to stay for Dean Strang's talk to the whole law school?
No, I didn't. I had to teach a CLE on federal criminal law in Fort Worth. That's why I picked him up from the airport and hung out with him for an hour, and then I had to hit the road for Fort Worth. So I really hated it that I couldn't be here, because he's like he really is like a hero to me. And he's so humble. I don't know if you guys know this. I spent most of my time talking to him about federal criminal law, and I asked him, do you do much federal work? And he's like, yeah, I do some. And I didn't even know at the time we had this conversation that he was involved in two of the most important federal cases before the U.S. Supreme Court. So he was like ground zero in some of these major cases. And if I were in his position, there's no way I couldn't have been, you haven't heard of United States versus Booker, which is like a groundbreaking case in federal sentencing law. And he was at counsel table before the U.S. Supreme Court on that case. He was co-counsel. And he argued another case called Buford versus United States in 2001. And you can go to oye.com. I don't know if you know about that. It's where you listen to all the oral arguments. And hear Dean Strang arguing before the U.S. Supreme Court. So he's really that humble, and that's really impressive. I know I've met several people who argued before the Supreme Court, and he would be the last person of all to even bring that up. So I was really impressed by that. Any other questions?
Do you have any idea why they agreed to limit his confession?
Yes, and this is something you're going to have to do, is to an extent speculate as to whether there was any strategic reason for doing so. And I'll tell you that if you read the appellate opinion, you can pull it up on Lexis or Westlaw. In this case, it lays out the reasons that trial counsel gave for not showing it. But the trial attorney essentially believed that showing the video created some sort of an ambiguity. Look, it doesn't make any sense. But they did lay out a strategic reason that interpreted one way the conversation with the mom when he said not really, when she asked him, well, did you do it, might look like a confession he made to his mother, which would be stronger than a confession you make to a police officer and inconsistent with the testimony that he gave in his own defense. That was their reasoning. I think it's bad reasoning because if you have a confession, it's done unless you're in damage control. And you have to show the rest of it. So, in my evaluation is deficiency absolutely. Prejudice is a closer call in this case, if I were a judge. So, I don't know if that helps you. I don't think there's a wrong answer, by the way, to this question. And I doubt you'll be graded off if you say yes or no overall. Any other questions? So 2 things. Look at the April 20th, 2007 transcript, and then look at the appellate opinion in the actual case, and it lays out the reasons that the trial counsel gave for doing that. And you have to essentially rebut those to show deficiency. All right, well, I'll let you guys out a little early if you don't have any questions.